Good afternoon, everybody. My name is Ian O'Herlihy, and I'm head of the Education Unit in Mason Hayes and Curran. And it's my pleasure to welcome you all, and hopefully for many of you to welcome you back to our webinar series for schools. A big welcome to anybody who's joining our webinar for the first time. I think that this is our 10th webinar since we started these last summer. And we've run webinars on a whole range of issues which we hope are relevant and useful to principals and school leaders. If anybody wants to access our previous webinars, we'll be giving you advice as to how you can do that at the end of this webinar. I suppose, having traveled the very challenging stop-start process that has visited schools over the last number of months, not least today in relation to the special schools. What I'd really like to do is to empathize with all of you principals and school leaders on the incredibly difficult journey that you've had to travel during this pandemic. And I suppose what I'd like to say to you is what we've been saying to ourselves on the schools team is hang in there, wait until this world returns to normal, and it will return to normal. You've done a fantastic job during the last number of months, and this is recognized throughout the country particularly by parents. So our webinar today we've titled Why Data Protection Affects the Way Primary Schools Operate. And it's important for me to say at the outset that this is not intended to be a comprehensive address to all aspects of GDPR and data protection in schools, because we'd want a whole day to do that. Rather, what this is a focus on the principles of GDPR data protection and how they play out in a relevant way for schools. And we're also going to be sharing with you some of the, if you like, cases or challenges or issues that we've had to deal with on the team, because we feel some of those are particularly relevant. I'd like to start by introducing my colleagues on this webinar. My partner, Paul Rochford, Fiona Shield, Anya Haberlin, and of course, David Ruddy, who will be well known to many of you from a previous life. So let's get started. Here's a kind of an overview of some of the issues that we're going to be looking at. Obviously, personal data, we've called that the new oil. We're going to be looking at what the law is, and we do this unapologetically because we're lawyers and that's what we do. We're going to be addressing the issue, who's the data controller in a school. We're spending a particular bit of time on data breaches, and we're going to be talking about how to handle those, the do's and the don'ts. Data management and retention is an issue that we feel may not have got sufficient attention in schools, so we're going to be looking at that. We're going to be sharing with you, as we call them there, some of our case studies, and a quick word on your policy. And we're going to be looking at that and doing a kind of a straw poll, which David will take you through in a couple of minutes. So what's the law? Well, the law is known either as Data Protection Law or GDPR. GDPR is General Data Protection Regulation. It's an EU-wide regulation, and it was brought into Irish law by the General Data Protection Act of 2018. I mean, just a word on Brexit. Obviously, the UK is technically no longer a member of the GDPR family, but it, like Ireland, has already introduced legislation pre-Brexit implementing GDPR, and for the moment, at least, they are operating under the same data protection regime as the rest of the EU for the moment. I've put up there the 7 principles of GDPR. And some of you will be familiar with having heard bits and pieces of those. And the reason I put them up there is that when we give advice in relation to data protection issues, very often a school will say to us, where is that advice coming from? Like, what's the background to that? And really the answer to an awful lot of what we'll be telling you on today's webinar is rooted in either one or more of these principles. So we'll be picking up, not on all these principles, but on the ones that are particularly relevant for schools as we go along. David.
Thank you, Ian, and good afternoon to everybody. You're very welcome. I'd like to start out by alerting you to a publication by the Data Protection Commission, and it's called Children Front and Centre. And this lengthy document, it's about 76 pages, looks at the whole question of the standard of protections that should be in place for children, because children are fundamentally data subjects. Now, a lot of this is skewed towards online providers, but equally, when you read down through the document, you'll see that there are 14 core fundamentals. And to their credit, they look at the whole question of children and consent. And they don't leave everything to parents, and they take the view that there are times when children should have access to information as of their own right. So in relation to that, I would imagine that might impact on maybe 5th and 6th class children. So this is a consultation document. It is important. And another area they touch on is the whole question of maybe your data protection policy should be child friendly too. So to that end, the team here in Mason, Hayes and Curran have decided that we're going to put in a submission to this consultation process. The closing date is the 31st of March. And in doing so, we would be happy to consult with IPBN and indeed with our management bodies so that we can find out what your views are. So we will be in touch with you later in regards to this consultation process. I want to come back to you there, Ian, in relation to this Data Protection Commission. What is the modus operandi of the DPC?
Thanks, David. Well, the Data Protection Commission, or the DPC as we call them, is first, it's the statutory regulatory body around data protection, GDPR. And its statutory function, or one of its main statutory functions, is to implement GDPR throughout Irish society, and also to hold data controllers and data processors to account for compliance. And like most regulatory bodies, it's compliance focused. There are two main ways in which the DPC may come into contact with schools. One is if there's a complaint made to the DPC, we'll be talking about in a minute, and the other one is in relation to data breaches, and we'll be talking about that in a minute as well. Complaints, schools who haven't been the subject of a DPC complaint may well ask, well, where would a complaint be coming? Complaints would normally come from parents on behalf of pupils, and also members of staff. And the complaints usually relate, they can relate obviously to a data breach, but they usually relate to a complaint that the school as a data controller has not responded either in a timely fashion or fulsomely to a data access request, or to a DAR, as we sometimes call them for short. And obviously, one of the important things, we'll talk about this later, is that you are aware of the 1 month time limit with which to respond to a data access request. It's fair to say that the DPC's modus operandi, in our experience with relation to schools, has almost always been to try to reach an amicable resolution, try to resolve matters by agreement. They do have powers to investigate schools, and it has happened, rarely, but has happened. They do have powers to issue a decision. They do have powers to issue fines and sanctions. We're not aware of any fines that have been imposed on schools, we have to say that. Where the DPC is strict enough with schools is the 1 month time limit. So we'll come back to that later, but you really need to keep a focus on that. And we'll be giving specific advice as to what to do with a view to meeting that time limit. David.
Thank you, Ian. And I'm now going to talk to Paul. Good afternoon, Paul. How are you?
Good, thank you, David. Good afternoon. Good afternoon, everybody.
Paul, just in relation to the question of breaches, over 4,000 schools, primary, post-primary, 1 million students, 100,000 staff, it's inevitable that there will be breaches. And you have drafted a list of what you call the top breaches. Would you like to take us through them, Paul?
Yes, thanks, David. And I think you're correct. Given that level of activity amongst that number of schools and students, it's going to be a fact of life that there are breaches. And it's possible that people may not comprehend that they have committed or observed a breach, you know, and maybe understanding some of the things we're talking about here might help them, point them in the direction of what a breach looks like. And the day-to-day things that can happen, you know, sending an email to the wrong recipient, or sending an email or some other form of communication without the proper consent or legal basis for doing so. Things like using BCC for mailing lists and getting it wrong is often something that people can run into trouble with. And then, you know, the ways we store data now in relation to, you know, cloud accounts, and particularly in the current climate where we're all learning remotely and files are being stored and processed through functions like Google Classroom and Microsoft Teams. Are those, you know, being compromised, or are they being shared inadvertently? And then the physical things like losing laptops or computers, losing USB keys, that kind of thing. So those are all things that can give rise to breaches. Then that is the technical or technological version of it. There are still the old-fashioned pen and paper versions of breaches of data. So for example, sending the wrong letter to the wrong person. So you put the letter addressed to person A into an envelope addressed to person B and send it off in the post. Or you send something that is sensitive or otherwise, you know, private to a particular individual, and you choose not to send it perhaps by registered post or courier, and it gets lost in the post. And that's then de facto a breach because you don't know where it's gone. So I think the message is to be alive to those breaches. And then once you're alive to what a breach looks like, what do I do with it? So we take a look now at what are the requirements in terms of data breaches. So you must report a breach to the Data Protection Commission where it presents a risk to affected individuals. And I'll come back and talk about risk in a wider context in a second. You must do this within 72 hours of becoming aware of the breach. And that's important to note, that becoming aware, because you may on a Friday afternoon find out about a breach that happened 3 weeks ago. So yes, it happened 3 weeks ago, but you've only become aware of it on that day. You now have 72 hours from that time that you've discovered this to make your report to the Data Protection Commission if that's what is required to be done. As well as the report to the Data Protection Commission, where it's assessed that the breach poses a high risk to those individuals affected by it, then you must notify those individuals as well. And in both cases, whether it's a notification to the DPC or a notification to the DPC and the data subject, or as may arise where there's no notification required at all, it is a requirement that you record their thought process in relation to that reporting decision. So how did you decide the risk level? And if you go to the DPC's website, there is very good guidance there in terms of assessing risk. So as well as the high risk and the normal risk categories, there are lower risk categories where there may not be a requirement for notification. But you have to decide that as the data controller. Then you need to note who made that decision so that they can respond to queries in relation to why the decision was made the way it was, and what level of risk was assigned to the particular breach. And as I said, there is very good guidance on the DPC website in relation to that. The other thing I think it's important to note is that when you make a breach, and you may do so in, you know, kind of a state of mild to medium to high panic, depending on the extent of the breach, you may then consider that your work is done. But typically you'll go off and investigate what happened in relation to that breach. If you get new information that may indicate the breach is less serious than first thought, or perhaps more serious than first thought. There is a facility, and you were obliged, and we good practice to update the Data Protection Commission in relation to any further information that comes out in relation to that breach. So I think if we put it in certain simple terms, you know, where somebody, maybe it's a member of staff, notices a breach, inform the principal, and have somebody who is responsible for driving that process. You investigate what happened, you assess the risk, the Board of Management then is informed and makes a decision on what action is to be taken, and then you record what action has been taken and the reason for that. And we can't emphasize enough I suppose the importance of timeliness and making that decision and dealing with it within the 72 hours. And it will help you to do that if you have the proper procedures in place to deal with breaches. So that's looking at your policy and looking at what you've been instructing staff in relation to that. But there is, and we are in our own experience, we've noticed there is a marked difference between the attitude of the Data Protection Commission, where you as the data controller identify a breach, you report it within the 72 hours and you provide a full report and you update it as required. And they will deal with you. And as Ian has said, you know, they have a certain approach in most cases as to how they want to try and resolve these things. However, it's a very different scenario, as you can well imagine, if you are aware of a breach and you don't report it within the 72 hours, and then the person who is perhaps the subject of the breach or some other person who maybe inadvertently received the data reports it to the Data Protection Commission and they're contacting you. And I know we've had occasions of that, and I think Ian has had a case where things worked out well for a client on the basis of prompt action only within the last couple of months. I'm not sure if Ian wants to kind of share a little bit of that story with us.
Ian.
Thanks, Paul. It was actually more than a few months ago, but we were contacted by an educational institution about a very serious breach that happened, and probably the most serious breach we've ever come across, where this institution, out of pure human error, had sent out sensitive personal data relating to a staff member to a bunch of parents. And this sensitive data included medical records and medical reports. So you can imagine this was a really, really serious breach. And once we had got our head around this, we decided, because it was serious, to make an immediate contact with the DPC's office, which we did with the institution, with the client in question. Now, I mean, I think the DPC's, the official we met in the spoke to in the DPC's office, was also a bit thrown by the seriousness of it, but, you know, took a note of it and whatever. What happened next really was an example that when you do the right thing, sometimes you can get lucky. Because about 15 or 20 minutes after we had spoken to the DPC's office, the solicitor for the data subject, for the staff member, because we had told the staff member what had happened, the solicitor for the data subject rang the DPC's office, and by coincidence, because there's a sizable staff at the DPC's office, got put through to the exact same individual that we had just spoken to. And the DPC's official said to the solicitor, we understand, oh yeah, I know all about that. The institution, if you like, has been on and has reported it. And that changed the dynamic completely in terms, first of all, of the DPC and our client, but also in relation to the solicitor and the client. Now, there still was problems. I don't want to pretend that this was all resolved. There was subsequent litigation about it, but there was a sense that the school had done the right thing and there was no element of cover-up. And that's a hugely important.
Ian, so the takeaway, what really yourself and Paul are saying is, even if you don't have all the facts, get something in before the 72 hours, let them know, and then afterwards you can fill in the gaps, as it were.
Exactly that, David, exactly that.
Thanks to yourself and Paul there, and we'll come back to you shortly. I now would like to draw your attention to a survey which was conducted by the National Association of Principals and Deputies, who are the sister organization of IPPN. And they conducted this survey earlier on in the month. And it's just to give us an idea as to where things stand. And bear in mind, these are post-primary schools. But as you can see, about a third of schools have been subject to an access request from a student or parent. I know it would be more parent at primary level, but that gives you an idea that there's quite a bit of demand on schools for information. Also, there have been requests from teachers and staff members, and that comes in at 14%. A very interesting one, do you feel confident in dealing with data access requests, which is up at 45%, which is much higher than, if you recall, anyone attending our last webinar on managing underperformance, because confidence levels were not high there, but obviously people feel much more confident in dealing with data protection issues. A very interesting one is, has your school ever been the subject of a data breach? And that comes in at 41%. Now, my guess there is that actually that figure should be much, much higher. And the reason for it is, if you think back to what Paul said, he said that all breaches must be recorded. Now, often, unless it's high risk, it doesn't go to the Data Protection Commission. So if you look at the chart Paul had about the teacher or staff member informing the principal, so I think that's a piece of work that staffs need to do, is you need to inform your staffs that if there is a breach, no matter how small, that they need to tell you so that you can make the assessment as to whether the risk is high or low. So and I think genuinely staff members mightn't report a breach because they feel they don't have to. So watch that space if you can. And finally, then there's a piece about feeling confident. Do you feel confident in dealing with the data breach? And that's up about 45%, which tallies with the request piece. So sometimes we can feel more confident if we actually have dealt with a breach already. And at this stage, I'm going to ask our colleague Sive Little in our events team. Sive is going to organize a very quick poll for us there. Sive, thank you very much. And this is going to take literally a few seconds. And please, I'm going to ask you all to vote on it. Do you think your data protection policy is fit for purpose? And we will be referring again and again to the data protection policy, but we're going to ask you this question now. We could ask you at the end, but we'll do that. So if you could vote on that, that would be great. Just to say that IPPN didn't conduct this survey because they previously conducted the Managing Underperformance survey, and they're conscious of the pressure school leaders are under, particularly at the moment. So happily, the NATPD people kindly agreed to share the results of the survey. So as you vote now, we will show you the results as soon as they come in.
I think just while we're waiting for the results to come in, David, it is worth mentioning that you know, we're all talking about a data access request as if it's some sort of just everyday occurrence. But in reality, we want to share with schools that when schools get a data access request, more often than not, it is related to somebody who has an issue or a dispute with the school, whether that's a parent or a staff member. So it's all the more reason why they really should be, you really should be on your toes in relation to those data access requests. I just wanted to share that bit of information with you.
Okay, thanks, Ian. And we've got a result. Do you think your data protection policy is fit for purpose? Of those who took part, 37% say yes, 10% says no, and 52% are unsure. And I suppose that's a fair enough snapshot. So thank you for participating in that. And hopefully you'll feel in a better situation as you sit through the webinar, and you'll find the other parts helpful also. So the next piece we're going to move on to is the questions in relation to GDPR. Agus tá cúpla ceistena ag Ian le haia áine ansach, so Ian Lanaraya.
Thanks, David. Well, is Anya attorney nua an burin scullina in Mason Hayes and Curran. Agus while I'm cúpla ceisna chur. Ceist amháin Anya, cé hé an riala hór sunrí sa scoil?
Gur bhíle maithagat íon. Tá ítach sásta bheith libh in Neamh agus tá fáilte romh. Tásúla go gúil si bh buint teanna fas an lár go dtí seo agus gúil si ag fálam anna cuid ólis. Agus tásúla go méid mé now an chuir leis an ólas sin. So I hope everyone is enjoying the webinar so far, and hopefully I'll be able to add more information to it. So an céad ceist ná cé an riala hór sunrí. So is ceiste seo a hagan isteach go rialta dún, agus mórtá lúte ag Paul agus Ian. Chun míú siimplí a chur is é an duine nó an chólacht ina bhfuil an tólas pásanta ina shelf acu agus atá faoi smacht acu. Go dlíthúil, déanann siad cinní na críocha agus na móna próseála sunraí pásanta. Agus I ggóhéics na scoile is é sin board banistíochta na scoile. So an freagar ná board banistíochta na scoile. So beag an board banistíochta freagarach as freagar a thuirt don comisiún cosan sunraí an DPC I gá. So beag an litir on DPC seolta chuig an board banistíochta agus beag an board banistíochta co-ragras a dhéanamh leis an commission. So just to answer this in English also, this is a question that comes in very regularly for us, and it's already been touched on by Paul and Ian. And to put it very simply, it is the person or the company that is in control of personal information. Legally under the GDPR, a data controller is a person, company or other body that determines the purpose and means of personal data processing. So in a school context, the data controller is the board of management. So the board of management will be liable for any breach of data protection laws, and all correspondence between the DPC will be through the board of management. So if you are notifying a breach, it is through the board of management. They make that notification.
Oh my God, agus ceistena, cén sort finála nó pinós a gheartar scoilena nuair a bhrisin siad dlíthe cosanta sunraí?
So leis an gceist seo, mar sóilda anna cuid díobh, nuair tháinig an rialacháin generalta maidir le cosanta sunraí an GDPR I bhaim ceapan mé 2018. D'arraigh sé an chuig go lámhseáil daoine agus cólachtaí sunraí pásanta. So thug sé a bhfad níos mó cuachta don comisiún fináil a ghearradh ar gcuoine, agus go háirithe cólachtaí móra, cólachtaí ina bhfuil cuid mhór sunraí pásanta ina seilbhe acu, cosúla Twitter agus Facebook agus a lehéid. Mar sin bín annach chuid inniucha agus scrúdú ag tarlúnt, nuair bhrisin siad sin dlíthe cosint sunraí. Now, gumrád nílach méid beag sunraí pásanta ina seilbh ag scoilne. Agus chun an éarna rá martá lúte ag Ian, níl éon ólas a gcuin ag an buinte seo ar éon ínáil geartha ar scoilne, so deanúch dún go léir an so. Ach is sin ráte tá sé fíorthaíteach bhfuil policy nó cód iompar cosint sunraí soléir agus ducht dagan ag scoilne chun finálacha a cheacant. De ná tuairteach an comisiún deist an scoil an sáú a réiteach, rih éon ínáil a ghearradh. Is féidir le duine gearán a dhéanamh leis an comisiún faoin cuí a dhearna an scoil a cuid sunraí pásanta a lámhseáil. Dar leis an comisiún, multar an aib a ordú leis an scoil zal a dagan siad chuig an comisiún. So mar sin an molla a thuairtha ná téigi in lech le éon bholla a hagan ón comisiún. Éon gearán a hagan isteach ó gcuoine, ó tuismothirí, ó lucht fearna, go das lua agus go héifeachtach agus ní tharlóach finála nó a lehéid. So just to put that in English, since the GDPR came into force in 2018, data protection laws have become a lot stricter, and the DPC has been given a lot more authority to issue fines for non-compliance with the regulations. And we have seen a lot of this in the media, with a lot of focus on bigger companies who hold hordes of personal data like Facebook or Twitter. And the level of scrutiny is much higher than, say, on schools, for example. Now, schools only hold a small amount of data relative to this, but that said, the regulations do apply equally to all entities, no matter how big or small. Now, to our knowledge, we are not aware of any fines issued by the DPC to schools, thankfully, which is good news for everyone here. But any individual is entitled to bring a complaint to the DPC in relation to the way in which their data is handled. As mentioned by Ian earlier, DPC preferred that a resolution is met through the parties, through agreement between the parties themselves, and that the complaint is raised with the organisation itself before being made to the DPC. So the advice would be have a clear data protection policy in place and deal with any complaints as they arise and do not delay. Thank you.
Ramila Magath, Anya, and just to take up Anya's point there, I'm going to call Paul back in, and this is in relation to the whole question of schools outsourcing their data processing to private firms and availing of software packages. Paul, certainly in a previous life, it changed my life because at a touch of a button, I could find all the information I needed to know on a particular student in relation to texts, communications, etc., sent out by the school and received. So Paul, should schools have service agreements in place, and how important is that?
Well, the short answer to that, David, is yes. So what the regulation sets out and what the Data Protection Commission requires is that where you have an arrangement with a third party to process the data that you are controller of, then you must have a data processing agreement in place. So that could be, as you say, and there are various packages there that schools use for dealing with data such as communications with parents and families and such like. So that is, you know, a kind of a big example. But even if you have, you know, a sole contractor or a small company comes in and does some work where they process some data or deal with data that the school holds, then you're required to have an agreement in place with them. And there are prerequisite elements to that agreement that have to be included. So, you know, things like the duration of the agreement, what's the purpose of the data processing, what type of data is being dealt with. It should be subject to the strict instructions of the data controller, unless there's some other statutory or legal requirement for the data to be processed in a certain way. You also have to deal with things like whether they might put the work further out to further subcontractors and the control of that. And also things like the security of the data, and if they have a breach while they're processing the data for you, that they're under an obligation to inform you of that as well. And then at the end of it, what happens to the data when the processing contract or agreement is finished? There should be a provision that the data is returned to the school or deleted, depending on the format in which it's in. So there are pretty strict kind of requirements for those agreements, and you must have one in place. So what I would say to people on the webinar today is, if you're aware that your school has an arrangement or has something in place where data is being processed externally to the school, go back and have a look, confirm that you have an agreement in place, confirm that it complies with the requirements of the regulation and the legislation. And if you do, fine, go to bed and sleep easy. If not, then that's something you're going to have to attend to.
So on that advisory note, Paul, thank you. We're now going to be joined by Fiona Shield. Fiona, good afternoon. How are you?
Good afternoon, David, and hello, everybody.
Fiona, great to have you. And we're going to start off, you're going to deal with a few issues, but the first one you're going to start off is the whole question of pixelation and that. So
yeah, thanks, David.
What's your take on that?
Yeah, our team, we've had a number of cases whereby parents have requested a copy of the CCTV footage relating to their child. First of all, it's important to note that CCTV footage of a child or indeed a member of staff qualifies as their personal data for the purposes of data protection law. You need to be careful with these kinds of requests for CCTV just for a couple of reasons. The footage shouldn't be handed over outright, as it most likely contains footage of other children or members of staff. And we've seen schools being asked to pixelate CCTV footage, which, for those of you who don't know, is essentially the blurring out of other people. And it's important to ascertain what exactly the person requesting the footage wants it for. Pixelation is really expensive, and There are a lot of companies who do it, and our experience is that it can run into thousands of euro very quickly for just requesting a couple of minutes of footage. If a request for footage is made, a good option for schools is to allow the parent or the member of staff who's requesting their data to review the footage on the school premises. And if there are other people in that footage, you need to get their consent. So best practice here really is to set out your position around the use of CCTV in the form of your policy. And it's also worth mentioning that the use of CCTV should be clearly displayed through signage around the school.
Thanks for that, Fiona, and I'm sure that that advice will be appreciated by our participants. Another area that we want to touch on is the whole question of data access requests, or Ian has called them DARs. This is an area where you do a lot of work in, Fiona. So can you address some of the questions maybe that were submitted there?
Yeah, sure. Thanks, David.
Thank you.
We see a lot of these coming through. In particular, I think Ian mentioned earlier from parents requesting their child's personal data. There hasn't been any let up of these over the past few months, so we're kept really busy with them. Ian touched on this earlier as well. The time limit is really important to note. It's 1 month. And there is arguably some degree of patience exercised by the DPC office, but you still need to be aware of the time limit and engage with the person who's requesting their data. And if you think you're going to have difficulty getting back to them within the month, be transparent about it. Let them know. Maybe look at narrowing the scope of what they are requesting. If it's a situation where a parent is requesting a child's data and they've been in the school for 7 years, there's obviously going to be a lot of documentation. So maybe look at narrowing the scope of what they're looking for. Be careful about what you furnish. A data subject is only entitled to their own personal data and nobody else's. It's a good idea to hold on to a copy of the documents that you are disclosing in the case that those documents are called into question. So we've seen situations where a parent says that they weren't furnished with X, Y, and Z, but we can refer to the copy that was sent out. So that's just something to bear in mind. We also mentioned earlier at the start of the webinar, the right to make a complaint. We've assisted a number of schools in dealing with complaints in relation to data access requests. And we often see complaints being made by parents or staff who have said that they're not happy with the level of redaction in the documentation, or they might feel that certain documents have been withheld deliberately. Again, if a complaint is made, our advice is just to engage with the DPC office and get help if you need it.
Fiona, I've heard you say in relation to redaction that you've had to deal with very complex documents and volumes of information. Is that right?
Yeah, that's right. Anya and I recently assisted a school on a data access request where, yeah, it ran into thousands of pages. So yeah, I mean, the volume can be absolutely huge, which is overwhelming for schools to deal with. Yeah.
So lots of strong coffee and a thick marker. Thanks, Fiona. We'll come back to you in a few moments. We're going to move on to another area, and this is the question of data transfer. So, Ian, at the outset, you talked about data being the oil, as it were. It's the necessary ingredient for a school to operate. There are obligations at times to pass on this information, but you know, sometimes some outside bodies and people see schools as a soft touch. And dare I say, even some solicitors will ring up the principal looking for information about a particular student where there's a custody dispute or whatever. So take us through this if you could, please.
Thanks, David. Yeah, I suppose that the starting point in relation to the transfer of data by a school is that you should always be asking yourself, am I complying with the principle of data protection and GDPR, the principle that states that, you know, a data controller, a school must have a lawful basis for sharing personal data with any outside agency. Now, you know, there are a number of options around this lawful basis. I mean, some personal data is shared by schools with an outside agency, for example, TUSLA, on foot of a statutory obligation. So schools, for example, are obliged under statute to furnish attendance records to TUSLA in school attendance records. Other data is retained and may be shared in certain circumstances with another lawful basis, which is consent. Now, the DPC under GDPR has a general preference for data controllers, including schools, not to over-rely on consent. So you may well find that as regards sharing data with outside agencies, apart from consent, there may be other lawful basis for sharing it. But just as you said, David, you should always have a kind of a question in your mind if you suddenly get in a request, for example, from a solicitor, maybe who's acting for one of the parents or guardians in a separation or a dispute situation, and ask yourself, do I have any lawful basis for sharing this information on foot of this request? And very often, if you come knocking on our door, we will say, you do not. And certainly you do not have a lawful basis if the other spouse objects. So just be careful. We've put down there a number of different issues. I mean, obviously, you're going to be engaging with things like Medmark and that kind of stuff, and you're required by department circular to engage with Medmark and furnish them with certain information in certain circumstances, but always ask the question, what is the basis, lawful basis for sharing personal data with an outside agency? That's just a message.
Thanks, Ian. And we keep going back to our data protection policy. We should have a section dealing with this transfer.
Absolutely.
So, yeah. Okay, thank you. Paul, I'm going to call you in again. Anya recently, she mentioned the fact that the board, the Board of Management, is the data controller. So with control comes accountability. And Paul, while I have you there too, just can you explain really what is personal data? Because sometimes the Data Protection Commission have said there can be confusion about what is personal data. So over to you, Paul.
Yes, David, and I think obviously if you're going to be accountable for something, you have to know what it is you're accountable for and how much and what type you have of it. So people can sometimes take the wrong end of the stick in relation to what personal data is, and we will all have had calls or emails from people talking about, well, I have a load of documents or emails here that refer to Mary by name, so obviously they're all personal data. Well, yes, they may be. But also if Mary's the second class teacher and there are a lot of emails that refer to the second class teacher in relation to a particular issue, which as Ian said, these requests often come in relation to an ongoing dispute. So if you've tried to avoid kind of the requirements of data access requests by not using a person's name, you should understand that doesn't necessarily get you around that issue. So what personal data is commonly understood as is data from which an individual, a data subject, is identifiable or can be identified. So either they're mentioned by name or they can be identified from it in some other way. So that being said, how do you deal with that? And when the GDPR came in first, there would have been a lot of discussion about doing data audits, or what we're calling personal data inventory. And that was to form a baseline to understand what data you were dealing with. And whether you did one at that time or maybe you did not, now is as good a time as any to do it or to refresh the one you did when GDPR came in first. And some of the questions that are on the slide there are the questions you need to be asking yourself in relation to the data that you as the board are data controller for. So who do you hold data on? Staff, students, etc. What data do you hold in relation to each of those categories of data subjects? Why are you holding it? What's the legal basis, as Ian talked about, for retaining that data? Who do you share it with? And again, what's the basis for sharing it? And do you still need it? And we'll talk about retention periods now in a minute. And that is something that, again, we will all have dealt with, where, you know, data access requests will have been made. We'll have asked the school to send us in whatever data they have. And the next thing, you're getting boxes of stuff because schools have kept every scrap of paper on a student or a staff member since the late 80s. You know, so you have to kind of do a regular spring cleaning, possibly on an annual basis, to say, why am I still holding on to this particular piece of data? And then the other thing about you know, your data inventory is it secure? So most people in that regard think of you know, digital security and computers and access to the internet, etc. And that is very important, and it's absolutely necessary to have that properly looked after. But then there are other forms of records that need to be retained in hard copy, and some of them need to be retained on the school premises in certain cases. And what arrangements do you have for those, the security of those documents and holding those? Do you have them in fireproof cabinets? Who has access to them? Who has access to the electronic storage of data? So these are all the questions you should be asking. If you haven't asked them of yourself or the person whose responsibility is for data controlling within the school, then you need to go back and go over this list again and review it.
So Paul, now is the time, almost 2.5 to 3 years on from the advent of GDPR, to go back and look at your policy and to look at all these issues.
Yes, and as I said, I think it's at least part of that exercise should be done on an annual basis to refresh the data status of the school, and you as data controller, and what are you continuing to hold, and are you doing something that perhaps creates an unnecessary risk for you as data controller by holding on to something you shouldn't be holding on to, or storing something in a way you shouldn't be storing it.
Thanks for that, Paul. We're now going to move on to the use of technology. And Fiona, I have 3 students in the house that are happily, busily, as far as I'm aware, working away on that. But there are issues for schools too, and risks, of course, when you start reaching out. Would you like to take us through some of them?
Yeah, sure. Thanks a million, David. So just a couple of points here. Staff should be really clear as to what apps and platforms that they're authorised to use, and they shouldn't be operating off any platform that hasn't been approved by school management. It's important to ensure that the most up-to-date privacy and security features are enabled. This is an easy thing to do, and there have been some horror stories in the media over the last few months where online classes haven't quite went to plan because certain privacy features mightn't have been enabled. So it's something to definitely look at. You'll see there on the slide, we've mentioned acceptable use policies. We've talked about these on previous webinars, and this is basically a policy that we feel some consideration should be given to. And if you don't have one in place, maybe look at putting one together. There's templates available online, but just bear in mind that it's really important that distance learning is something that's covered within this policy. So yeah, perhaps something to look at.
Thank you, Fiona. And we move on then to the question of emails. So a few just points in relation to that. Yeah,
thanks, David. Paul has kind of touched on a couple of points in relation to this earlier. So we're all using emails more than ever. This arguably puts us at more risk. Staff shouldn't be using personal email addresses to conduct any school business, and this should clearly be communicated. And it's important that staff are aware of the difficulties which misdirected emails can pose. Teachers have to exercise care in relation to who they are sending the emails to and what data the email contains. So, you know, I do it myself. Before you press send, just double check, you know, that you're sending it to the correct person with the correct attachments. And just really to have a clear protocol in place so everyone understands how email communication is supposed to work.
So communication with the staff is vital. That's the takeaway that I get from you, Fiona.
Yeah.
Thank you. The next piece here is in relation to, and it has been referenced already, storage and retention. And Ian, you have 2 very interesting photos there amongst all the information, lots of boxed files and a magpie. Explain.
Well, thanks, David. Well, I think the first thing to say in relation to the top picture is that we kind of really hope that your storage room in your school doesn't look like something like that picture, because if it does, we would probably be presuming that you're having an excessive retention of data. The magpie, as we know it, is traditionally renowned for basically a collector of other people's property, random perhaps collector of other people's property. So, you know, people would tell you that when they've found magpies' nests, traditionally they've found all sorts of particularly shiny things, including jewelry and the Lord knows what. So you don't want to be a magpie, and you don't want a storage room like it's in that picture there. So we've just put down a big load of different categories of data that a school might have. And there are two fundamental principles, and I know I'm always back to the principles of GDPR and data protection. You know, one is that the data you retain should be limited to what is necessary for the purpose for which it's retained or stored, or sometimes called processed. So, you know, you shouldn't be just retaining data because without thought and thinking, oh, that might be useful in some time in the future. And another principle of data protection is that it shouldn't be retained. Data shouldn't be retained for longer than is necessary for the purpose for which it's retained. So that's a duration issue. And that's really what I want to look at here and talk about here for a second, because, you know, some data in your school will be retained forever. For example, your school registers, you know, you're obliged by law to keep those forever. But attendance records, for example, that you have kept for the purposes of the Education Welfare Act obligations and furnished to TUSLA, we'd have to have a question mark, like you're not going to keep those forever. So what I'm really provoking here is a discussion in your school to look at how long you should be retaining different categories of data. And really what I'm kind of provoking you to do is to prepare a retention schedule, which will state what periods of time various categories of data will be retained. And that data retention schedule should be cross-referenced in your policy. This is something that we've been saying throughout. Now, I've given you a link there for you know, a sample data retention schedule. I think this was drawn up by the JMB, who were given a job of work to do by the department, but I think it's kind of been adopted by all of the other management bodies as a sample or a suggestion of a data protection schedule. But it's not something that you should just, if you like, not even consider and review. It needs to be discussed within your school, and so that if you're ever challenged as to why you're retaining certain data and for what period you're retaining certain data, you will be able to refer to your data retention schedule and cross-reference in your policy, and you will be able to show that this isn't sort of an ad hoc decision or a random decision, that it's a decision based on a policy in your school, which is always better. There's also, I think, a resource bundle, which we would refer you to there by IPPN, which has a lot of helpful information around this kind of general area. And just while I'm speaking, can I just say a thank you to IPPN for their support in relation to this and previous webinars, and just we're very happy to work with them in relation to this.
Yeah, and thank you, Ian. Just a question in relation to access to teachers' notes. Often you can have a situation, maybe a disciplinary situation in a school, where the principal has asked the teacher on yard duty for a report, and they'll give a report, and the teacher, the principal may refer to this report when he's speaking to the parents of a student, particularly in a serious situation. And frequently parents will ask for a copy of that report. And the situation would be that they would be entitled to it, provided sensitive information about other students is redacted. So I suppose the key question is, what is the purpose for which the notes are kept? Is it on a professional basis about students? And do we as professionals, as teachers, rely on what we have in that report to deal with parents? And if we do, yes, the data subject, the pupil is entitled to a copy of it, and be aware it can be retained in electronic mode or in hard copy, and even a handwritten note. I would say that we need to be aware of what's known as the household exemption. So if I have a diary at home, my own private diary, and I like to record maybe events of the day or that, there is no entitlement to have access under GDPR to that personal correspondence. So as we draw to an end of this, to this webinar, Ian is going to pull a few themes together in our last two slides. So Ian, over to you there.
David, thanks. Yeah, this is just an element of repetition here. Okay, data access requests. One of the big faults we have is schools not getting started immediately when they get a request. There's a 1 month time limit, and too often schools come looking for advice or support up near the time limit. Start early, collect the data firstly is the first thing we'll be asking you to do. Tell us what data you have. Get going early so you're not up against a time limit. We spoke earlier on about the issue of consent of the student. That's an issue that's going to be examined by the project that is being commissioned at the moment, and which David referred to earlier on. Keep a copy of the data that you've sent out in a DAR, because if there's a dispute later and you haven't got a copy of what you sent the data subject to parents, for example, staff member, you're going to be 1-0 down. Should a request be in writing? Well, I think technically a data access request, I think technically no, but in practice, if it's a verbal request, technically the 1 month time limit should start from then, but you should always ask the parents or staff member, whatever, to confirm the access request, because if there's a dispute about the scope of it, it's not in writing, we're going to be in difficulty. And lastly, and this is just picking up something I've spoken about a minute ago, establish a policy on retention of records. You know, have your retention schedule cross-referenced with your policy. And just protecting personal data. Has any consideration been given to an update on the policy? Has any recent staff recently been briefed on data protection policies, protocols for storage? These are just some things were there. And one thing I should just mention before we finish is kind of data or cyber attacks, because these are a hot topic at the moment in the world, and you'll see how people have managed to hack into systems and get people's personal data. You should all, we're advising schools at the moment, you should all check your insurance policy, because it may be that you do not have cover in your policy for a cyber attack. And if that is the case, just to say that we are aware that one of the big brokers who deal with schools, perhaps more, but certainly one of them, has arranged for additional cover in case you got a cyber attack and you were your data or parents or students' data was stolen. So just to mention that. David.
Buelam buchas a gael do Ian, Fiona, Anya, August, Paul, for sharing their considerable knowledge and experience with us this afternoon. Thank you. We'd also like to acknowledge that Mason, Hayes and Curran have a dedicated privacy and data security team. They generally work with worldwide companies like Facebook and Twitter, but we're in the fortunate position that we can get in touch with them. We can phone them and email them to get the latest up-to-date information. Finally, I'd like to sincerely thank you on this day of all days and all the controversy and tensions we've had over the last few days for joining us on the webinar and for participating in our poll. I hope you found it useful. Ian is going to send you a mail shortly just with a link to a recording of the webinar. And as always, we'd like to say, if we can help you in relation to any of the issues raised, or indeed any other broader or wider issues, feel free to contact any member of the team. So thank you very much and goodbye for now.